Can the central government dismiss a democratically elected state government at will? This question lies at the heart of the landmark Supreme Court case SR Bommai v. Liaise Union of India, decided in 1994. The case scrutinized the potential misuse of Article 356 of the Indian Constitution, which allows for the imposition of President's rule in a state when there is a failure of constitutional machinery. The backdrop of this case involves SR Bommai, the then Chief Minister of Karnataka and a leader of the Janata Party. In 1989, his government was dismissed by the governor under Article 356, who claimed that Bommai had lost majority support in the assembly. However, no floor test was conducted to verify this claim. Instead, the governor sent a report directly to the president, leading to the imposition of president's rule. This incident was not an isolated one. Throughout the 1970s and 1980s, Article 356 was frequently invoked, often against opposition rule states, raising serious concerns about the central government's misuse of power. Several state governments challenged similar dismissals, and these petitions were eventually consolidated with Bommai's case. The legal questions before the Supreme Court were profound. Could the courts question the president's satisfaction under Article 356? Was the imposition of president's rule justiciable? Did the governor need to prove a loss of majority on the assembly floor? What constitutional limits existed on the center's power to dismiss state governments? In a historic ruling delivered by a 9-judge constitutional bench, the Supreme Court held that the president's decision to impose president's rule is indeed subject to judicial review. The court clarified that the president's satisfaction is not absolute and can be challenged. If a proclamation is found to be mala fide or based on irrelevant material, the court has the authority to strike it down. Crucially, the court emphasized that the proper forum for testing a government's majority is the assembly floor, not the Raj Bhavan. The governor cannot bypass a floor test by relying solely on reports or letters. The judgment made it clear that using Article 356 without proving a loss of majority on the floor is unconstitutional. Additionally, the court established that if a proclamation is deemed invalid, the dismissed government can be reinstated. Another significant principle from this ruling is that secularism is part of the Constitution's basic structure. If a state government acts in a manner that violates secularism or promotes religious intolerance, it could lead to a constitutional breakdown. In summary, the Supreme Court placed clear restrictions on the center's power under Article 356. President's rule is now justiciable, a floor test is mandatory to determine majority, and arbitrary dismissal is unconstitutional. The principles of federalism and democracy are integral to the Constitution and must be upheld. The impact of the SR Bommai case is profound. It stands as a bulwark against authoritarianism and the misuse of political power. The judgment strengthened federalism in India and redefined the balance of power between the center and the states. Following this ruling, the invocation of Article 356 significantly decreased, and its application became subject to stricter constitutional checks. This case also reinforced the role of judicial review as a guardian of the Constitution. SR Bommai v. Union of India remains one of the most influential decisions in Indian constitutional history. It protects state governments from arbitrary dismissal, upholds the spirit of cooperative federalism, and reaffirms that no authority, including the president, is above constitutional scrutiny.